You imagine the court jester as a pampered entertainer, but he was rarely paid a salary. He was compensated in land, in cloth, and in titles that were almost never his to sell. This reality turns the entire profession into a single sharp question. How do you convert proximity into survival when the patron's favor is the only bank you have? The fantasy offers you a seat at the right hand of the monarch, a bauble, and the unique license to speak truth to power while the rest of the court trembles. In the brutal arithmetic of the royal household, however, you are not defined by your wit. You are a singular piece of inventory, a human asset, and an object of display, a cost center that never appears in the official wages column. The discrepancy between your presence in the king's eye and your absence from the account books is your first real problem. Open the household ledgers and look for your name in the payment rolls. It is frequently not there. Your name is absent from the wage columns because the jester held no contract. You were a fixture of the household kept for the monarch's amusement. Payment was not a transactional wage. It was a patchwork of in-kind grants. You received land, elaborate cloth livery, titles, and patents for monopolies. These were not liquid funds you could spend at the tavern. They were assets tethered to royal favor, and that favor was fragile by design. The office was a conversion problem. You held proximity to the throne, but that access was unpriced and revocable. Your survival depended on your ability to transform that fleeting attention into durable property. Some men secured heritable land, while others collected empty titles that evaporated the day they were dismissed. This remains a brutal ledger. 3 men 5 centuries apart paid 3 different ways. The man who was publicly stripped of his coat and thrown out of court is the one who died rich. Forget the idea that you are being paid for your wit. The Crown does not issue invoices for punchlines. You are entering a system where your income is not earned by the hour, but granted by the gesture. Some men traded their dignity for a seat at the table. Others traded proximity for a piece of the kingdom. The office itself was a vehicle for royal patronage, but the reason one jester died in a borrowed room while another built a legacy lies in whether they understood the difference between a costume and a capital asset. That question is the business. The law made a sharp distinction, and the distinction was the entire ledger. On one side was the natural fool, often a person with a cognitive disability, kept in a household out of duty or amusement. He was fed, clothed, and slept on the floor. Legally, he was a dependent, a ward, not a person capable of holding property or entering a contract. He was not paid because he could not be. He was an asset of the household, not a participant in its economy. Then there was the licensed fool, the artificial fool. You held an office. You were a performer with a specific role under the king's hand, and the household accounts acknowledged you. This distinction was everything, because the office granted you 2 specific, recorded privileges. First, a formal standing in the household, a title that marked you as a servant of the monarch. Second, an entitlement to livery. The court issued clothing that proved you belonged. In 1535, Henry VIII granted his fool William Somers 16 yards of velvet and satin for his clothing. In 1637, Charles I paid £26 for a suit of crimson velvet for Muckle John. This was not a salary. This was a visible grant of status, a costume provided so the performance could be believed. But standing is not income. That crimson velvet is not a financial asset. You have been given a wardrobe to wear in the king's presence, not a deed to sell. Your compensation is not a contract. It is a bundle of privileges that exist only as long as the household chooses to issue them. The livery stops when the favor stops, and it depreciates the moment you put it on. You are buying a position in a household, not a claim against its treasury. So the question that matters is not what the office provides in a good year. It is what, if anything, survives when the good years end. And to find the benchmark for that, you have to look at the oldest deal in the book. It is a deal that makes every later arrangement look like a temporary favor. The year is the late 12th century. The king is Henry II. The man is Roland Lafarder. And the transaction is not a wage, not a gift, but a heritable holding in the Suffolk village of Hemmingstone. For this you must understand feudal tenure. Roland does not rent a cottage, he holds a manor. The price is not rent in coin, but grand serjeanty, a specific, personal service owed directly to the crown instead of the military duty owed by a knight. Roland's service is simple, annual, and spectacular. Every Christmas Day, he must appear before the king at court and perform 1 jump, 1 whistle, and 1 fart. The record books, the Red Book of the Exchequer from 1212, say he holds 100 acres. An earlier roll from 12005 says 30. The structure of the deal is what counts. This is not a salary. It is a grant of property conditional on performance. You own the land. The performance is the rent. Watch what happens next, because this is where the deal transcends mere payment. Roland dies. The manor passes to his son, then to his grandson. By 1205, it is in the hands of his granddaughter and her husband. The bloodline continues. The obligation is eventually dropped. The family begins paying a cash fine to the crown in lieu of the annual leap, whistle, and fart. The performance ended, but the property did not. This is the benchmark, a single, transformative act of conversion that any later jester would recognize as the perfect score. You turned a moment of royal amusement into a freehold asset that could be inherited, sold, or held. Every shilling of pension, every yard of velvet livery, every gift of silver plate that flows to a later court fool is measured against this. They all fail the comparison. Roland did not just get paid, he got the door. But the door itself is not the whole cost. To enter the room, to even be considered for a deal like this, you must first look the part. And looking the part will cost you more than you think. That livery is the first cost, and it arrives looking like a gift. Henry VIII grants William Somers 16 yards of velvet and satin in 1535. Charles I pays £26 for a single suit of crimson velvet for Muckle John in 1637. To grasp that sum, know that a skilled thatcher in those years earned a small daily wage. The crown is handing you more than a year of a craftsman's labor, sewn into a doublet. The purpose is display, not wealth. You wear the king's investment on your back, so the court can see the depth of his favor. But you do not own that cloth in any economic sense. You cannot melt down a velvet doublet for coin. You cannot, as a rule, sell the livery your office grants without inviting a very direct question about your loyalty. It depreciates with every feast, with every rainstorm, with every new season that makes last year's pattern obsolete. The moment your name leaves the household book, the entitlement to the next suit vanishes with it. The cost of looking the part is a perpetual overhead you pay in obligation, not cash. This is the structural trap. Your entire compensation package is illiquid by design. You are a single-client business with no employment contract, no fixed term, and no notice period. Your revenue is measured in yards of cloth and the warmth of a smile. The overhead is that you are paid in something that looks like assets to everyone watching, and is worth nothing to you when the music stops. What was left on the balance sheet was only what you had managed to turn into property while the smile lasted. Favor is not income. The jester's true work, the work that determines whether you die in a borrowed room or on your own land, is conversion. Turning proximity, which is unpriced and revocable, into property, which is priced and durable. Look at the ledger. Archibald Armstrong, fool to James I, secured a patent in 1611 for 2 pence on every pipe of wine imported into Ireland. That patent was property. He also secured a pension of £50 per annum. But here is the legal detail that changes everything. The first grant was made during pleasure, meaning it stopped the moment the king stopped being pleased. 1 month later, a second grant was issued. This one omitted the critical phrase. It began pay pension for life, independent of royal mood. That 1 month gap between 2 pieces of paper is the single most valuable thing in this entire story. It is the moment an expiring option became a durable asset. Compare this to Richard Tarlton, the most famous comic in Elizabethan England. In 1583, he was sworn a groom of the chamber, with a fee of £20 per year and the right to wear the royal livery. He owned taverns. His name was in published works. Yet when he died in 1588, the record is blunt. He was poor. His fee was £20. His diversifications were likely held in his name, not in structures that survived him. His title was an office, not a deed. When the Queen's favour paused, the ledger showed a title, some liveries, and a small annual fee. No patent, no heritable land, no annuity detached from a breathing monarch. Roland Lafarter converted a flatulent performance into 30 acres in Hemmingstone. The land passed to his son, then his granddaughter. Armstrong converted a joke into an Irish wine patent and a re-granted pension. Tarlton converted his proximity into fame and liquid spending. The man who was publicly stripped of his coat and thrown out of court understood the conversion problem. He held assets that survived the loss of favor. The man celebrated by the realm held assets that did not. The difference was not talent. It was what the talent was turned into while the doors were still open. This is not an accident. It is the business model. You have the template now. A cash line consisting of pensions and fees, convertible assets like patents and monopolies, and property like land or heritable grants. To see how these lines actually balanced, you need to examine Armstrong's full ledger, year by year, with the cash separated from the convertibles. The pension was £50. The patent was a steady royalty on every pipe of wine. The grant was an estate. These lines sustained him once the court doors slammed shut, proving that while he lost his standing, he had successfully liquidated his royal connection into private capital. Look at the ledger of Archibald Armstrong, and you see a masterclass in separating ephemeral cash from permanent assets. In 1618, he secured a royal pension of £50 per year for life. To measure that correctly, compare it to the labor market of his peers. A skilled thatcher in this same era might earn a small daily wage, struggling to scrape together a modest annual sum. £50 represents a comfortable middle-ranking income, but it remains a wage tethered to a monarch's ongoing pleasure. If the royal temper shifts and the court door slams shut, a pension granted at the king's will is a brittle, fragile thing. The real wealth on Armstrong's balance sheet sits far below the cash line. In 1611, he secured a patent for 2 pence on every pipe of wine imported into Ireland. That is not a salary. That is a permanent, scalable royalty on the logistics of an entire kingdom. When you add the Irish estate granted by royal favour, you see the true objective of his office. These are durable assets that generate their own yield, independent of his presence at the banquet table. This is the structural divide between the performer and the proprietor. Contrast this with the material benefits issued to someone like Muckle John, who received a single suit of crimson velvet costing £26 in 1637. To the observers in the Great Hall, a man dressed in £26 of velvet looked like a titan of courtly status. To a ledger, it is a depreciating liability. You cannot sell a royal livery to a creditor to cover a debt, and you cannot bequeath a clothing allowance to your heirs. The entitlement stops the moment the household stops issuing it. It is a tool of the performance, not a store of wealth. It is a high-cost overhead you must wear to stand in the room, and the moment you leave, the value evaporates. Most entertainers spent their entire lives chasing these temporary visible perks, trading their long-term autonomy for the immediate warmth of proximity. They functioned as human assets held by the household, fully dependent on the next smile from the throne. They mistook the conspicuous display of the livery for the actual security of an estate. They failed to realize that proximity is a revocable option, not a tangible commodity. The men who died with something to show for their time were those who treated every moment of royal favor as a currency to be converted immediately into land, monopolies, or patents. Everything else was merely the cost of being seen. The accounting of a good year looks identical for every court performer: fed, housed, clothed, and present. But the bad year is where the truth emerges. The gap between them is only revealed when the favor pauses. The man who holds the manufacturing patent survives the exile in London, while the man who only holds the title and the velvet coat vanishes into the records the moment the royal door closes. That is not a small difference. That is an entirely different business model. Now that you know the real numbers behind this trade, the two collapses we look at next reveal exactly how thin that margin really was, and almost nobody sees the end coming for the most famous man in England. The contrast between these lives is a matter of asset management. Richard Tarlton was a superstar of the Elizabethan stage, a man who moved through the court with enough skill to hold the title of Groom of the Chamber. His position granted him a regular fee of £20 per annum, alongside the standard livery entitlements that came with his proximity to the Queen. He understood that being a singular attraction was not enough, so he built a secondary income stream through the ownership of a tavern and an ordinary. Yet, the ledger reveals the fragility of his model. When he died in 1588 at a house in Shoreditch, the reality of his wealth collapsed instantly. He left behind no significant estate, and his family was forced to bury him the same day. His income was tethered to a royal appointment and a trade that required his physical presence. When his health failed, the income stopped, and the assets he had built were insufficient to sustain a legacy. Archibald Armstrong, by contrast, occupied the role of the fool with a different economic intent. In 1618, he secured a pension of £50 for life, a sum that provided a far more stable floor than Tarleton's fluctuating earnings. But Armstrong went further. In 1611, he had already obtained a patent to collect 2 pence on every pipe of wine imported into Ireland. This was a toll on trade, a permanent extraction mechanism that functioned regardless of his current status at court. When he insulted Archbishop Laud in 1638 and was physically ejected from the king's presence, the court stripped him of his coat and his official standing. By every expectation of the time, this should have been the end of his prosperity. Instead, the loss of his court position functioned as a forced retirement that allowed him to focus entirely on his private capital. He moved to London, transitioned into the business of money lending, and continued to collect his income for another 34 years. The beloved favorite died broke, while the man who was publicly shamed walked away with his capital base intact. This divergence represents the fundamental gap between income and assets. Tarlton operated as a high-earning employee who failed to bridge the gap into capital ownership. Armstrong used the proximity of the throne to graft a toll-based patent onto his personal balance sheet. The jester's office was a temporary, high-risk window for the accumulation of things that could survive a king's changing mood. That gap between the two men was not created in their final days, but years earlier, through decisions they likely viewed as trivial at the time. To understand why one of these men left a family with an estate, while the other was buried in relative silence, you have to look at how they processed their good years versus their bad years. The good year and the bad year look identical from the outside, but they reveal entirely different mechanics of survival. In a good year, you occupy the center of the household. You sit near the king at the feast, and your status is reflected in the quality of your livery. You receive that annual pension of £50. You hold the patent on imported wine. You are visible, you are paid, and you are secure. The household accounts treat you as an essential overhead. Now run the bad year. The royal favor pivots. You are ejected from the court. You are stripped of your coat. The pension, which was granted during the king's pleasure, is revoked the moment that pleasure ends. The wine patent is declared invalid by the next royal favorite. Suddenly, the household accounts that once defined your life have no record of your existence. This is where the divergence occurs. If your income was exclusively in cash or consumable livery, your balance sheet is now a void. You have no capital, no claim to the property you occupied, and no residual rights. You are a single-client enterprise that has been involuntarily shuttered. Archibald Armstrong's ledger shows the difference. He did not merely collect his pension. He held the wine patent as a distinct asset. When he was expelled from court, he did not lose his entire business model. He simply shifted his operations to the city, using his accumulated capital to move into money lending. He had converted his proximity into a tangible, portable asset that operated independently of the royal household. Contrast that with Richard Tarlton. As a groom of the chamber, Tarlton drew £20 per year. He was at the height of his fame, the only man allowed to speak truth to power. Yet his wealth remained tied to the office. When he died, he possessed no diversified business interests to bridge the gap between his royal service and the needs of his estate. Despite his fame, he left almost nothing. The gap between these two men is the margin between an employee and an asset holder. The good years were not for collecting status. They were for hedging against the day the doors locked. If you treat your access as a salary, you are a dependent. If you treat your access as an option on property, you are a landlord in waiting. This is a story about the exit strategy. You are not building a performance record. You are building a balance sheet that survives your employer. The men who survived the court were the ones who treated their office as a temporary bridge to permanent property. Now that you know the real mechanics behind the office of the fool, the model we look at next is far more precarious, and almost nobody sees the math behind it coming. Roland's descendants held those 30 acres long after the king who granted them was in the earth. The performance was a memory, but the property was a legal fact. That is the fundamental disconnect of the office. A court career relies on a patron who can vanish or turn cold. If you are only as wealthy as your standing, your net worth is pegged to the temperament of one man. When favor dries up, you are left with nothing but livery that carries no weight in a court of law. Richard Tarlton was the most famous entertainer in England, yet he died in a borrowed room, buried the same day. Archibald Armstrong understood that his access was a wasting asset. He converted his proximity into a pension and a manufacturing patent before he was ejected. He spent his final 34 years as a private lender. You do not get paid for being funny. You get paid for what you move out of the palace before the doors close. The men who understood that their wine patents and their land grants were their true balance sheet were the only ones who survived the liquidation of their own careers.